So we are going to talk about immigration compliance now, and immigration compliance is, of course, dear to our hearts because that's why we have a job. Otherwise, you can file anything and not worry about being in compliance, right? I'm going to get the clicker. Thanks. And just so you know, I'm not as tall as Laura. Because our firm is inclusive and diverse, asked for a riser. So that's why I'm standing here looking like I'm almost as tall as Laura. But we are very fortunate to have join us, to have with us on the panel, Nora Olson Lovenstein. Did I say it right?
Not really. That's okay. It's really hard. Blufstein.
Okay. Nora Olson Blufstein.
Very nice.
So
Hi, everybody.
Nora is a partner in our employment and labor law group, and we often partner with her on employment issues. What I love about what we do is that we're very clear to our partners and colleagues here that we do immigration, and we would be happy to answer any questions related to immigration law. But if it's an employment law issue, we are fortunate enough to have our employment law group to go to and really partner with them on difficult issues that may arise involving employment and labor issues. Also to my right is Ashley Roth, who is an associate with our group, and Ashley has been with us for almost 5 years now, right? 4, okay. She just had twins a year ago, and they're about to turn 1. So it seems like it's been 5 years. So we're going to talk about immigration compliance, and we're going to have 2 individuals also join us on the panel. And it's really our individuals that we're going to use in hypotheticals throughout our presentation, Safia and Alan. And the discussion that we're going to have about immigration compliance is going to be centered around some of the activities and issues that Safia and Alan has brought to their employer, Minco. Minco is a fictional company that we created who hired Safia and Alan at a university job fair. And so the way that we have framed our presentation is really what are the immigration-related compliance and employment law related issues that may arise throughout the life of a foreign national's employment relationship with you. And so that's what we hope to do with our presentation. And the first encounter that you're going to have with your foreign national employee is determining whether they even need visa sponsorship or not. So in our story, Safia, when she interviewed at the university job fair, did not really disclose that she needed employment sponsorship or what her immigration status is because she wasn't asked that question at the fair. And so the company has hired her, and what you should know is that employers are allowed to ask questions as to whether a job applicant needs visa sponsorship or not. And in our materials is a non-immigrant fast fact, which lays out permissible questions, but we're also going to talk about it now. The Office of Special Counsel with the Department of Justice is responsible for addressing allegations of discrimination based on citizenship, immigration status, national origin, and also document abuse cases and situations where there's retaliation because of a report of or allegation of discrimination. And the Office of Special Counsel with the Department of Justice has been very busy in the last 5 to 6 years. And it recently, in June, issued a really interesting technical assistance letter where it stated that if you have a situation where a foreign student is eligible for optional practical training, and you know this, you can ask whether they are eligible for optional practical training through the STEM program, which, as you know, gives them an additional 2 years. And in the letter, the Office of Special Counsel stated that the employer could disqualify a foreign student because the student didn't qualify for OPT STEM. And their justification is that if you're basically comparing a foreign national who has OPT versus a foreign national who has OPT STEM, that they are not protected under the provisions related to citizenship, discrimination based on citizenship. They don't fall under that protected class, and thus that question is permissible to ask. But really, with Sophia, the company hired her and didn't realize until after 3 months of employment that she needed visa sponsorship. And what the company should have done, as I mentioned, is ask her that question as to whether she needed visa sponsorship in the future or in the presently as she's interviewing with them, or in the future, and whether she needs visa sponsorship to work legally for the company in the U.S. And if they had asked her that question, they would have known that she would have needed visa sponsorship in the future because she only presented a EAD based on her F1 status for optional practical training. What could get really messy, though, is let's say the company, after it learns that she does need sponsorship, makes a decision that they don't want to sponsor her, and they are maybe interested in letting her go. Nora, could Minco terminate Sophia because after they've already hired her? She's been working with them for 3 months now, and they find out that she needs sponsorship. Her work authorization is still good for a year because she has optional practical training. Can they make the decision to terminate her because they're not willing to sponsor her for a visa in the future?
So Lon's asking a really great question because on the one hand, from a sort of lawyer's perspective, this is great. This is really juicy, and I'll explain why. There's lots of good arguments on both sides. From a business HR perspective, this is incredibly aggravating because there's not a clear answer. It's going to be a question of what your risk tolerance is. So what do I mean by this? So we've got Sophia. She's got time left before her work authorization expires, but Minco doesn't want to sponsor her, so can they terminate? Well, if you look at these Office of Special Counsel letters, on the one hand, they're saying, well, she's not protected from citizenship discrimination because she's not a U.S. citizen or national, she's not a refugee, she's not an asylee, and she's not a recent lawful permanent resident. So, okay, she's not protected against citizenship discrimination, we can terminate. Well, that's not the full story because then the Office of Special Counsel goes on to say, but perhaps she could still raise a claim for national origin discrimination. So anybody's protected against national origin discrimination regardless of what your immigration status is. So you've got sort of, you're okay under citizenship discrimination, maybe not okay on national origin discrimination. I would say as a litigator, I'm not super concerned about national origin discrimination if we've got good evidence that the reason we want to terminate her doesn't have anything to do with what country she came from, whether she's got an accent, whether there's other things going on. But she's got enough that she might have a claim. So if you're trying to stay out of court and not hire Frederickson to represent you in litigation, you've got to be careful about that. One final piece is USCIS also has some information on their website that talks about how you can't refuse to hire an applicant because they have a document that will expire in the future. So I think you've got a lot of things that are in the mix that are raising the potential issue and making it riskier.
Great. Thanks so much, Nora. I mean, literally, we get these kind of questions, and we do have these very difficult discussions among each other as to the risks involved. And Nora mentioned that the Immigration Service, in its guidance for I-9, states that if you have an individual, you've already made the decision to hire the individual, they're filling out the I-9 now, and they present to you a document that's going to expire within the next 6 months, you cannot make that decision now to withdraw the offer of employment because their employment authorization is going to expire in 6 months. That's the guidance we've been given, with the caveat of the warning that it may open you up to being vulnerable for a claim based on discrimination based on national origin. Okay. So let's talk about the I-9. You've hired Sophia now, and you need to prepare the I-9 for her. And guess what? We're getting a new I-9 very soon. We don't know exactly when it's going to happen, but the OMB, the Office of Management and Budget, has approved the new Form I-9, and USCIS has 150 days, I believe, to issue the form, and we will see if it does. It's supposed to, but we're not quite sure what it's going to look like, if it's going to be exactly the same. It should be, though, and if it is, it's going to allow you to fill out the I-9 electronically. It's going to be an electronic fillable form, but what it means, though, is that it doesn't mean that you can sign it electronically or your employee can sign it electronically. It means that you can just fill it out, print it, then sign it. So that's one of the new features. We also did some comments for these new I-9 forms too when they issued it for comments. And another feature that we learned was that the new I-9 form, because it can be filled out electronically and fillable online, there will be drop-down boxes for the list of acceptable documents to provide further details regarding what the documents should contain and what documents are acceptable. And I found those details very helpful with the drop-down boxes. There's still some information that leaves us to still question, like, what are the acceptable USCIS documents that they list on List C, which they don't go in detail to list out what are those acceptable documents issued by the Immigration Service. But I found that the drop-down boxes were very helpful. There's also going to be some content changes in the new I-9. For example, other names used will be the new question instead of other last name used. And so there will be some different questions that you may see in the form that will look different from the existing one. So we have been told on I-9 Central that the current version is going to be valid until January 21st, 2017, which means hopefully that we'll see the new I-9 form being officially rolled out before that date. Okay. So just to give you an overview of current immigration enforcement trends too, in addition to I-9, we're seeing a lot of, as I previously mentioned, technical assistance letters from the Office of Special Counsel, but also we've seen an increase in investigations conducted by the Office of Special Counsel based on national origin, citizenship discrimination allegations, and document abuse. So document abuse is when an employer will ask an employee for documentation outside of what is permissible as part of the I-9 process. For example, if they say you have to show your green card, as part of the I-9 process, you don't have to show a green card. The employer has to allow you to pick from the list of acceptable documents. So telling someone what they need to present is considered document abuse. And so just to give you an idea about the increase in numbers, in 2007, the Office of Special Counsel did not issue any penalties at all to settle discrimination allegations. In 2008, there were the amount was 45,000 in penalties, and in 2013, the amount in penalties issued by the Office of Special Counsel amounted to 1.1 million. So employers paid for allegations of discrimination claims as a result of investigations by the Office of Special Counsel in the amount of 1.1 million in 2013. Did I? Yes. So another trend that we are seeing is I-9 re-audits. As you know, in 2008, there was a huge increase in the number of I-9 audits. And now what we're seeing is the Immigration Customs Enforcement going back to those who had already been audited and re-auditing them. So make sure your I-9s are still in order. With E-Verify, we are also seeing an increase in activities from the E-Verify Compliance and Monitoring Unit. E-Verify conducts what we call compliance desk monitoring. If they see there are strange activities happening, they will call the employer and say, why did you submit 200 E-Verify requests or inquiries where the employees started employment 6 months ago? So with those type of strange situations, you want to be proactive and transparent and call E-Verify if you, for some reason, determine that you untimely conducted E-Verify after you completed the I-9. Just be proactive with E-Verify about any mistakes or corrections that need to be made. We found that they have been very helpful and cooperative, and let's just hope they do stay under desk monitoring and they don't come knocking on your door. Another enforcement trend that still continues is the fraud detection and national security investigations or site visits from the Immigration Service. If you're filing non-immigrant petitions or even immigrant petitions, always be prepared for a potential site visit. And so let's go to the next situation that we often see, which is, I'm going to skip over audit files and talk about situations that may arise where there are changes in non-immigrant employment. And so we have Sophia working, and changes are coming to Minco. USA Inc. has purchased Minco, and Sophia is being transferred to California, or that's what's been announced. So let's talk about what that means for Sophia. She is now in H-1B status because the employer has agreed to sponsor her for H-1B status. And what we want to talk about is amended or new non-immigrant filing required if there are material changes. So if there are changes to the terms of the employment, the Immigration Service has stated that you only need to file amended or new non-immigrant filing if there are material changes. What are material changes? And that's what makes it difficult, and what we often discuss in regards to material changes. It could be a location, a geographic change, and Ashley's going to talk about that later on with H-1Bs. There could also be situations where if it is a change in the position, the occupation change, if there is an occupational change, that could be considered material. If it's a natural progression within the same job family, that may not be a material change, and it's really good to contact your legal counsel to determine whether that may constitute a material change. Employment outside of the MSA area, as I mentioned, is considered a material change, and if you have to file a labor condition application as part of your H-1B petition, you will need to file an amended H-1B petition with the Immigration Service. And that changed a couple of years ago with a case called Matter of Simeo, where the Immigration Service stated that if you have a H-1B petition and you transfer your employee outside of the geographic location covered by your labor condition application, you need to make sure that you also file a new petition, H-1B petition. And this has really impacted our IT consulting clients a lot because of third-party placements. And what we recommend is that employers really strategize with legal counsel at the beginning of the case in order to determine what are the potential locations that the employees may be placed at, and make sure that we add that on the petition before you file it. Corporate restructuring is an issue. Deborah mentioned a little about that earlier. And moving from part-time to full-time employment, or vice versa, would be considered a material change too that may require filing a new petition. For the H-1B status, for example, anything less than 35 hours a week is considered potentially part-time employment. Okay. So we have here the no match SSA letter, or the Social Security Administration no match letter situation that may come up when an employer gets a letter from a third party stating the Social Security number doesn't match up with the information that they have for an employee, or they may get an anonymous tip here. So, Ashley, we're going to move it around a little bit, and I'm going to have you talk about that. Is that okay in regards to the Social Security no match situation?
Certainly.
Okay. So Minco employs Alan, and he, as you know, was hired with Safia, and for his I-9, he presented a I-551 lawful permanent resident card, and Minco receives a tip that Alan is undocumented because it so happens that Safia and Alan are having problems here with each other. And Safia told her manager that the green card he presented is really not his green card. Is that sufficient information for Minco to terminate him or take action?
No, it is not. So the key here is whether or not you have actual constructive knowledge of the fact that Ellen might not be authorized to work, or whether you just have an anonymous tip, which could be based on a variety of reasons in a contentious relationship, or someone's speculation, or facts. Basically, you just can't be sure that what somebody else is telling you is actually 100% accurate. The same goes if you receive one of these Social Security no match letters, or some other indication from another agency perhaps that a Social Security number might not match up. We're seeing this more and more as Social Security numbers are used more often in things like healthcare administration, or benefits administration, where other agencies are checking these numbers. And they might contact the employer and say, hey, there's a discrepancy here. This number doesn't look like it matches up with this particular employee. And so then the employer comes back and says, well, what do I do? Should I terminate this person because the Social Security number doesn't match? The answer is still no. So for I-9 purposes, for work authorization purposes, you always go back to those documents that the employer or the employee presented to you upon hiring when you're completing the I-9. And you look at those documents and you say, do these documents appear genuine, and do they appear to pertain to the person that's providing them to me? If the answer is yes, they're work authorized, pertain according to those documents. The employer does have a duty to investigate these claims, though. So if you do get one of these notices or information that something might not be correct, the employer needs to go back to the employee and ask them to resolve the issue. Maybe it's just a matter of a typo. That would be fantastic. Maybe there is some other issue that the employee needs to take care of, but they are responsible for addressing that issue and bringing back the proper information to the employer.
Great. So this is a situation that recently arose where we had an employer get a Social Security no match letter, meaning not from the Social Security Administration, but from actually a benefits company that administered all of their benefits, and stated that, we have a situation where the Social Security number doesn't match. And so we talked to the client and asked them to, follow up with the employee, give the employee an opportunity to explain or why there may be a mismatch. So we had this employer do this. Nora, what could happen if the if the employee didn't respond to the request to follow up with the Social Security Administration? Could the employer take any type of action to terminate based on failure to follow up?
So I see this as a disciplinary issue. If you have done what you're supposed to do, you've checked the documents, looked at the I-9, you then tell the employee they need to get this resolved, you should expect that they do it. Now, it may take a fair amount of time to get it resolved. Lon's probably going to mention that, like maybe even 120 days. I think that doesn't surprise me. Anything with the government takes a long time. So you can't necessarily expect a quick response, but if you really aren't getting any response, if the employee is doing nothing and you check in periodically and they kind of sidestep the issue, I would treat that as any other performance issue where you're telling an employee to do something, part of their job duties, and they're really not complying. I wouldn't jump probably to termination right away, but perhaps you've coached them. Then you give a written warning. Maybe you give another written warning, and then you move to termination if you really are not getting a response. I would think in most situations, if you get to the written warning stage, hopefully that will, get the employee to comply.
So if we have a situation where the employer may have some type of policy in place too, where we call it, which Nora taught me that it's really not good to call it the honesty policy, and the employer informs you that perhaps that indeed was not their Social Security number. Some employers, if they have that policy in place, and what do you normally call such a policy, Nora?
So what Lon and I were talking about is probably, if you think of your employee handbook, a conduct policy. So if the employee is telling you something that you think is not true, and you've got a good basis to believe that they're lying about what's going on, again, you can look to your policies to say, do you have an employee conduct policy that maybe it has a whole list of things that you can't do at work, and one of those is to be dishonest. Or maybe it's a more generic general policy that gives you lots of leeway to discipline based on that. But if you think the employee is not being truthful and you've got pretty good evidence, you can look to your policies to take action.
Okay, great. So in your materials, the Office of Special Counsel did issue do's and don'ts regarding Social Security no match issues and what you should do in order to follow up with those in those situations. Feel free to take a look at it. We were really grateful when that came out because for a period of time it was very unclear as to what an employer needed to do as we were in the middle of I-9 audits too in 2008. And so the guidance they've given us is probably the best we're going to get. Nora mentioned, what does reasonable time means if you do ask the employer to follow up. And it's really hard to say. In some of the discussions by the Office of Special Counsel, they have mentioned 120 days as a marker, but it really depends on the situation and the facts around the situation. So we are now going to talk about other difficult I-9 scenarios that you may face. And Ashley, can you share with us some other difficult I-9 scenarios. Let's say Alan comes to Minco after we find out that, you know, the Social Security number he presented is not really his, and he wants to provide you with new employment authorization. What happens now?
So if Alan comes to you and presents new documents, you know, if it was actually, it's a social security number that didn't belong to him and he presents something brand new, you look at it and you say, well, this is a different identity. Who was that guy before and who should I be employing now? Can I still employ this person if what he told me before wasn't actually true? Well, you look at the documents. If the documents, again, appear genuine, appear to pertain to Alan as he's presenting them to you, and they meet the work authorization identity requirements of the I-9, yes, you can accept them and you can continue to employ him going forward because he's now presented you with documents that establish his identity and his work authorization. Now, it does bring in issues, again, as Nora was explaining about a conduct policy. And so this kind of comes down to an employer's preferences and an employer's past history of how they've treated other employees. Some employers are perhaps in industries which this may be a more common occurrence. And they want to keep their employees, they like their employees, they want to keep them with, and you know what? To them, it doesn't matter if they had a different identity before, they're work authorized now and they want to keep them on staff. They can do that because the documents that have been presented appear genuine on their face and appear to pertain to that person. Other companies take the position that they, you know, either were lied to or have an issue with the dishonesty that was initially presented, and that's where they look to their conduct policy and how they're going to treat that employee going forward.
And this is a stronger position if you do want to terminate because he's actually brought forward new documents showing that the old documents are not him. So that is a much stronger case for saying that somebody was not being honest than if you just didn't sort of like their verbal answer.
And if this does happen and you do want to go forward with the employment, what you would do then is you complete a new I-9. So the idea is basically that the identity has changed, so the information in section 1 has changed. So you complete a new form with the new information. The employee, again, fills out section 1. You fill out section 2, verifying the employment. You keep the original hire date, though, in section 2. And then you attach the new I-9 that you've completed to the old one and keep that with the rest of your I-9 information. And we did see this situation come up a fair amount when DACA came out. So there were a lot of people who were working under false names or false information. And then when the program came out, which Deborah described earlier, that gave work authorization to children who were brought here by their parents, and now all of a sudden have that ability to work. They presented their employers with new documentation. And so USCIS issued this guidance at that time of what to do in those situations. And that's where they have explicitly said that you are allowed to continue to employ those workers, and then what you do in that situation is complete the new I-9.
And what was really confusing about it is if you're an E-Verify employer, what do you do now? If you're an E-Verify employer and you've completed a new I-9, right? For this individual, do you complete a E-Verify request through? Do you submit it also? And there was a lot of confusion about that because the general rule under E-Verify is that you don't conduct E-Verify again if someone gives you proof of employment eligibility because through re-verification, if their E-Verify or their employment authorization's running out and you need to re-verify them. When they give you new employment authorization, you don't E-Verify them again, right? You just complete Section 3 or continue with the I-9 and complete their employment eligibility. And in this situation where USCIS stated you can complete a new I-9, it wasn't really clear to the employer whether under E-Verify they should run this I-9 again through E-Verify because they had already run a prior case through E-Verify, and the conclusion was because it is a new I-9 that you should just go ahead and run it through E-Verify. And that's pretty much the general rule with E-Verify, is that if you're completing a brand new I-9 for an employee for whatever reason except in re-verification situations, that you should be able to conduct E-Verify. And again, E-Verify is a agency, I mean, the people running it are, I think, friendly enough for us to pick up the phone and ask, in this situation, what should I do? And that's what I would recommend. Another technical assistance letter that came out, Ashley, if you could discuss it a little bit, is can an employer, when they're doing an I-9 audit, internal I-9 audit, which we recommend you do at least once a year, is conduct an internal I-9 audit. And in reviewing the I-9s, you determine that, you know what, this document that Alan gave, of his green card doesn't really look like a valid green card. Can the employer ask for a different document?
Yes, the employer can. So if the documents, again, don't appear to be genuine or reasonably related to the person, they can request additional documents. This is a bit outside of your normal rules of provide, the list ABC documents, and the employee can pick which ones they want to provide to you. But if you take a look at that and you say, you know what, that doesn't look right, and you're not expected to be forensic experts, particularly with some of these documents. I mean, green cards have changed a number of times over the last couple decades, basically. So have Social Security cards. So you're not responsible for knowing what those cards issued in different years look exactly like. But if you're given a green card that spells America wrong or something, it's clearly not right. And in that case, you can ask the employee to provide alternative documents that would establish their work authorization and identity.
Great. So I'm going to go back to corporate compliance policy because we do have some time. Laura, we have until 4:30, which is in 10 minutes, right? I can't see. I'm sorry. I lost my glasses or I broke them. So really, I can see some, but not all. So that's why I had to ask. All right. So let's talk about then, if we have until 4:30, a little bit about compliance files and how long they need to be kept. For immigration purposes, there are requirements that the employer needs to keep, for example, the H-1B public access folder, the perm audit files, and other files. Ashley, can you address some of the requirements in terms of H-1B public access folders?
Sure. So each of the process types that are listed here, whether it be non-immigrant or immigrant, has certain regulatory requirements of documents that the employer must keep on hand. For the H-1B, it is in fact a public access file. It's something that anybody can come and request to see at any time. Whether or not that actually happens frequently is another story, but it must be available for inspection, particularly also in the event of an audit, is when you'll most likely see
Wage
it.
and hour investigation.
Exactly. And so information that's kept in the LCA files includes things like the actual wage being paid, an assessment of the prevailing wage as determined by the Department of Labor or as assessed through determination that we can help you make. The evidence that the notice has been posted to other employees in the company, or if there's a collective bargaining agent that governs your employees to them as well. Evidence of a benefits package that's offered, and also a copy of the certified LCA that pertains to that particular H-1B application. And this information, again, if we're assisting you in this process, we put it together for you so you can make sure that it's all there. There will be additional things that you'll have to add, but we'll give you guidance so that you can make sure you have a complete LCA file. And that has to be kept accessible for 1 year beyond the expiration date of the LCA. Again, LCAs are usually 3 years to coincide with the 3-year H-1B. If an employee is terminated prior to that and the LCA was withdrawn, it's 1 year from the date that the LCA was withdrawn.
Okay. And so, Nora, what if there aren't regulatory requirements for maintenance of certain personnel or immigration files? What would be your general advice regarding how long an employer should maintain those files?
So with the, personnel file, there are a lot of different answers, but depending on what's in it. But for the I-9s, We want to look at the later of 3 years from the date of the I-9 or 1 year after termination. So in other words, keep it throughout the course of the person's employment, and then when they're terminated, figure out which one's longer. If they've been, just a short-term employee, that 3-year date will be your date. If it's a longer-term employee, it's going to be 1 year after termination.
And we talked about if the documents are just other immigration documents, whether it's strategy or anything like that, general documents where it's not regulated that you have to keep it for 5 years from the date of certification or anything. We thought 1 year from the date of termination would be a fair amount of time to maintain those documents if it's not regulated under the law as to how long you have to maintain it. Sounds right?
That's usually a question that I call Lon and Deborah and Ashley on.
All right.
Just one retention thing I just wanted to add is when we send you copies of your petitions, make sure to keep them accessible. Again, it's not a regulatory requirement, but we have seen in these FDNS worksite visits, they'll ask for copies of the H-1B petition, copy of an L petition. So that's good to have easily accessible as well.
Great, thank you. So Sophia's, she's had problems with Alan. We have the restructuring where they want her to move to the West Coast, and things aren't really working out here. She doesn't really want to move, and she refuses to take the assignment on the West Coast. Her manager really likes her and is concerned about what would happen if the company terminates her because of these conflicts. And so we're going to talk now about separation considerations for employment sponsoring non-immigrants, because we get this question a lot. What happens now? I've filed a H-1B petition for this individual. I filed a labor condition application with the Department of Labor attesting that I'm going to pay this individual for this amount of salary and time, and also file with the Immigration Service, and now you're considering termination. A question that we get a lot is, Nora, do I still have an at-will employment situation because I filed this non-immigrant petition, or am I tied to this individual for the duration of the H-1B petition?
So you're not tied to the person. They still are, assuming you haven't bungled at-will employment in your offer letter or something like that, saying you're going to guarantee to employ them for a certain period of time. They're still employed at will. Now, whenever I talk about at-will employment, I like to remind employers that it's a great concept in theory, but there are wrinkles to it. So at-will employment means the employee is free to quit at any time for any reason, doesn't have to give notice. And similarly, the company is permitted to terminate the employee at any time for any reason, with or without notice. Now, that for any reason has a big asterisk next to it because it has to be a lawful reason. You can't terminate them for an unlawful reason. Unlawful reasons are things like because you're discriminating against them based on protected class, which would include national origin, because they complained that the company was doing something illegal and they're protected under a whistleblower statute. There are a whole host of reasons why terminations can be unlawful. Keeps me employed because I have to counsel all of you on that. So when you're looking at termination, the immigration status isn't going to be a problem here, but you need to, like with any other termination, think about how risky it is. How many protected classes is Sophia in? Has she complained about anything recently? What are the things going on that might make her termination more risky than it otherwise would? And that's not to say you can't terminate somebody. It just means that if you do, it's going to be riskier than if they were not in a bunch of protected classes.
Great, thank you, Nora. So another question that we get asked a lot also is, I just want to employ this individual for the 5 year that they're here in L1 status as a person of specialized knowledge, or I want to keep them here as a E2 essential worker. We really have no interest in sponsoring them for the green card. Can I make that choice? And our advice is, yes, you never are required to sponsor a foreign national for lawful permanent resident. It's about your business needs and also your relationship with that employee. But you know, you want to be strategic about it and think about the investment that you've made in that individual, but under the law, you're not required to sponsor any individual for lawful permanent resident status. Now, there are certain requirements that an employer has to go through in order to meet the regulatory requirements for termination in certain non-immigrant categories. So, for example, I'm looking at my H2 crowd here. For H2, which is temporary workers, Deborah described the H2 temporary worker category. If you terminate the individual before the employment contract has ended, as an employer, you do have to report to the Department of Labor and the Immigration Service. So depending on what visa category they're in, there are certain regulatory requirements in terms of reporting their termination earlier than what the petition called for in terms of their work contract. Ashley, do you want to talk about the H-1B situation for termination? Because there's been some cases about H-1Bs where employers have been ordered to pay back wages because they did not undergo all the procedures required for termination, right?
Right, and that's really the key, right? Is, you know, we see that an H-1B is valid for 3 years, so what's the big deal if we just let it expire? Well, back wages. That's why. That's why. So if an employee is terminated, say after year 1, you don't want to be liable for 3 years of wages. You want to make sure that you effectuate that termination in consistent with the requirements by the government. So there's really 3 things that you'll need to do. The first is expressly terminate the employment relationship. Basically, make sure the employee knows they're fired or terminated, or if they happen to quit, whatever it happened, whatever reasoning for the separation is, it has to be clearly conveyed to the employee. The second is notifying the Immigration Service of the termination so that the petition can be canceled. And that's done in 2 ways. One is basically just sending a letter to USCIS saying that this employee who has been employed pursuant to such and such H-1B is no longer employed by the company as of this particular date. The second part is you want to withdraw the LCA. So the LCA was filed with the Department of Labor, so you want to make sure that you cover both agencies that are governing your H-1B petition. Finally, for an H-1B, you also need to provide the reasonable cost of return transportation for that employee. This is true of some of other visa types as well, but you need to actually make that offer. If the employer refuses it and doesn't accept it, for whatever reason, you're not required to hand them money or give them a physical ticket or something, but you need to make that offer. And one consideration too is that it just has to be the employee. If they have a family of 10, you don't actually have to pay for all of their spouse and their children. It's just that particular employee. And then when you're making this offer, it has to be, it's an offer to offer of return transportation to their country of last residence. So if you're, thinking this employee wants to take a vacation and go to Aruba instead of back to the UK, you don't have to pay for the ticket to Aruba. That's all on them. But you would need to pay for the ticket to the UK if that's where they were from before they came to the United States. One way we see employers do this quite often that's pretty efficient is to include it in a severance letter of some sort. And so that covers 2 bases here. It's the offer of return transportation plus that express notice. And then often you also see or recommend people include a time limit. So you have basically 30 days to accept this offer. We'll buy you a ticket. And then if, after that 30 days they don't accept, you're covered. So an employee doesn't come back a year later or something and say, well, I'm ready to go now. Yeah. And you have to buy the ticket. So.
Yeah. Termination is a really difficult situation in any employment relationships, but when it comes to foreign nationals who are relying on employers for sponsorship, there are many additional issues that I think employers have to consider, and we deal a lot with those questions and help navigate our clients through those situations because their status is usually dependent on on you, the employer sponsoring them. And once that petition is pulled, if they do not seek other sponsorship or can find other sponsorship, it is a huge life change for them if they have to return to their country. So there are options in terms of considering how much time you give notice, and we work with our clients all the time to determine what would be fair to the company and to the foreign national as you make those decisions. But I promise you, most of our cases do not end up in termination situations, and we are usually celebrating with our clients on their employees getting green cards. And I do want to give a shout out to Stroon, who was with us earlier today, because Ashley and I partnered on assisting him with his O petition, and I know that someone mentioned that, the O may not be that difficult, but a person of extraordinary ability, that's a difficult threshold to meet, and he did meet that threshold. So you had a person of extraordinary ability presenting to you. And the point, though, is that, even though we're ending with termination and separation here, in most cases, we are able to find situations where the employer has been able to support their employees in green card sponsorship, and they are able to get lawful permanent resident status.